Good afternoon, members of the public. All 9 commissioners are in attendance at this public meeting. We welcome members of the public, your comments and questions, which we will handle at the conclusion of the meeting after the discussion of the recertification regulations. In terms of those questions and comments, we will, as we did at our last meeting, permit, if you identify yourself, to appear before us and to make any comment or to ask a question. We ask that you confine your appearance to no more than 5 minutes, and we ask that you confine your questions to the recertification regulations which have been discussed and which we intend in large part to constitute the discussion at the meeting. Let me also say that in the question and answer segment of our Zoom, there will be on occasion members of the staff who may respond to your questions because your questions are specifically directed to them. And so that may occur. And then beyond that, with regard to the questions and answers, Attorney Povich will be, as he has done in prior meetings, attempting to perhaps consolidate some of the questions. And again, we want them to be directed to the recertification regulations, which constitutes the major portion of our discussion today. We also would like to inform you that we will not be responding to any question which is asked anonymously. And I think with that, I will turn to the first item on our agenda, which is the Executive Director report. Enrique, please.
Thank you, Madam Chair, and good afternoon, commissioners. I'll be very brief. I just have a couple of updates since our last meeting. I want to remind commissioners and the public that we update our frequently asked questions from time to time, and we're constantly updating our content in our website, and that continues to be the best source for answering and obtaining information relative to the recertification process, but anything having to do, of course, with the post commission. We have in different sections, depending on the questions, different sections are answered in different portions of the website. But because we are getting questions, we continue to update with some regularity those FAQs. So please look at that resource as you go along. We're doing some validation in real time of agencies that are submitting information to post recertification information, and that's also one of the reasons we'll continue to update the sections in our website, because we continue to want to make sure everybody understands the process that we have set forth. That really concludes my report, commissioners. I'll come back with more updates at the next commission meeting whenever we can schedule that, to continue updating you on the submissions, the number of agencies that have submitted, the number of officers that have submitted information, and the great efforts of the team and the staff that is working very hard and continues to work very hard towards the recertification process.
Thank you, Enrique, for that report. Thank the members of the staff who have been assisting you in your very hard, diligent work. Any questions or comments from the commissioners with regard to the report from Enrique? If not, I will move on to the next item on the agenda, which is the proposed recertification regulations. And I turn now to our General Counsel, Randy Ravitz, and to Attorney Lon Povich.
Thank you. I will share on my screen a presentation regarding the recertification regulations. Okay. Now, there were questions raised previously about the process of developing these regulations and the extent to which There was discussion of their provisions, the extent to which there were opportunities for public comment and so forth. And it's understandable because different people have become aware of them and become involved in the process at different points in time. So they might not realize all that has occurred prior to this point and all that has led up to where we are now. So I thought it would be helpful to go over some of that background. What we see looking at the minutes from the last commission meetings, really going all the way back to December, is that these regulations are built on a foundation of provisions that have been developed and discussed previously. And those provisions were made available through public materials on the commission's website. They were discussed at meetings. There were questions at the meetings about those provisions and responses to those questions. We invited public comment on those provisions outside of the meetings, both by offering invitations within the meeting for people to provide comments outside, and through meetings that occurred outside the formal commission meetings, where the executive director and others would invite people to provide their feedback. And when we received feedback, it was incorporated. The regulations also incorporate existing statutes and other regulations. And so in certain ways, they're built on a foundation of things that the legislature has done, things that are already in existence, but they include provisions that help us to implement those other provisions that have been put in place by the legislature or that the commission has previously put in place. So I'll just elaborate on that a little bit. Within the brackets on these next few slides are citations to the latest proposed regulations, so the version that's going to be coming up today, that are derived from the item that's listed here. So it might not be the case that what was approved previously is exactly the same as what's in the regulation, but what was approved previously provided a foundation for what's in the regulation. What's in the regulation is derived in some way from what was done previously. So back in December, the commission approved or discussed at least a process for certifying new officers. And there was particular attention given to agency attestations, to the background check requirement, how that would be satisfied, the oral interview requirement, how that would be satisfied, the officer questionnaire that's been the subject of discussion, and the physical and psychological evaluation requirement. Those are the things that got a lot of attention. And so what was done there, as you can see, provided a lot of the foundation for what are now sections 705 and 706 of the proposed regulations. And the commission in that meeting approved a series of documents and a series of measures related to those certification standards for new officers. Similarly, in the January 14th meeting, the officer did the same, and it approved a form that combined an agency attestation regarding the background check and the character and fitness evaluation for officers. The form also included a longer officer questionnaire than what is being used in the recertification process, and a set of instructions that round out how the process is to work. And again, those helped provide the foundation for what is being done now. Then on February 15th, the commission turned from the certification for brand new officers to the recertification of current officers who obtained a certification through the session law at the end of 2020. And there was a plan for that was discussed at the commission meeting. And it covered how each requirement that's listed in the statute may be satisfied. It introduced this or reintroduced this concept of agency attestations of certain matters. It dealt with the treatment of the physical and psychological evaluation requirement and laid the groundwork for what's incorporated now, including a way of treating the different thirds of the alphabet the same, even though they are given different expiration dates in the session law. And it included a plan to administer oral interviews by developing questions or topics to be covered that the commission would then provide to agencies. The commission also in that meeting approved a conditional recertification plan for officers who are unable to complete their in-service or their bridge training due to hardship. And That plan is actually, it's in its own way incorporated into the new regulations, but also that concept of conditional recertifications for times when an officer has experienced a hardship or has some other reason for not being able to satisfy a requirement. That features even more prominently now than it did then. But it's a concept that's been in existence for several months. Then on March 16th at the meeting, the executive director discussed the recertification process. He discussed adjustments that were made based on agency feedback. And the commission approved the plan that I just mentioned, the recertification plan, with certain revisions. It elaborated on the concept of character and fitness. So right now in the current regulations, there's a place where it says that an agency may take into account whether an officer presently exhibits, and it lists a series of characteristics. That was approved back in March. At least most of what's in the regulation was. And that was partly to respond to questions from law enforcement. And at that meeting, what was cited was the source for that list of characteristics. So namely, Massachusetts Supreme Judicial Court decisions interpreting the same phrase, good moral character, but in the context of bar admissions. That was mentioned at the meeting. And this plan also added procedures that would require agencies to substantiate if they did not find an officer to have good moral character and fitness for employment, and allowing for the officer to provide a response. So those are key components of the current regulations. And it reaffirmed that plan for officers with hardships that I mentioned a moment ago. The commission also approved the first part of an agency attestation form and instructions that spells out a lot of this. And the commission then at that point, based on the commission staff, based on the full commission's action, began implementing this plan, mindful of the fact that officers with last names that begin from A through H will see their expirations expire by statute on July 1st of this year, unless there's a provision that would allow for it to be extended. Then on April 4th, again, the executive director discussed the recertification process, communications that have been had with agencies and individuals, and he encouraged agencies to check the commission website for updates on the recertification process. The commission also approved an 8-question questionnaire and instructions that's a scaled down version of what had been approved previously in January for the new officers. Then in May, again, the executive director discussed the recertification process, communications with interested parties regarding the same, and he provided some further guidance regarding the questionnaire in response to questions that had been received. And then the commission took up a plan that was basically the forerunner for these new regulations, a plan for how applications for recertification will be processed. And that plan included this continuation of the original certification period that features prominently now in the proposed regulations, this conditional recertification process and how that would work, how an inability to satisfy each of the requirements would be treated, and basically putting them into categories based on their nature and the circumstances. And it reaffirmed again this conditional certification for certain officers with hardship that I mentioned a couple times. And the commission also in that same meeting approved a set of regulations regarding hearings related to commission decisions. It's now at 555 CMR 110, and that's relevant here because that process is incorporated into these new regulations. So then coming to May 19th, a draft of these very same regulations was discussed at the commission meeting. And I won't go through that list, but as you can see there, what was discussed May 19th, a few weeks ago, is really a plan that included, or a draft of the regulations that included all the principal components of what's before the commission now. Then in late May, so shortly after that meeting, the commission put out an invitation for public comment on its website. And some comments were received from one organization representing law enforcement, and they resulted in revisions to the draft regulations that I discussed last time. And last time that was at the meeting of June 1st. What was put before the commission was a revised draft of these regulations. And they clarified that continuation of the original certification period, the character and fitness analysis, the oral interview requirement, those were the major revisions. And again, an invitation for public comment was posted on the commission's website after the meeting. As of early this morning, we hadn't received any public comments to those. We did receive one set of comments just this morning. I'll now run through the sections in the proposed regulations, which again, as you can see, are built, and I know that the commissioners know this, but my recitation of that background is largely intended for members of the public who might be wondering how we got here and how much this has been discussed and subject to public scrutiny. But I'll go through the sections now of the proposed regulations. They start with sections 7.01 through 7.03. Those sections define some basic terms. They provide for the process to begin with commission instructions to agencies. So we're taking on the burden ourselves to explain to agencies how this works and to provide them with materials. It provides that agencies can obtain extensions of time if they need to, and through a really simple process of making a request. And even when they do so, they are asked in that as part of that to provide a type of application for each officer. So in other words, when they list the officer's name on a roster, that constitutes an application on behalf of that officer for recertification. And that's significant because there's a statute that provides that when a timely and sufficient application for renewal of a license is pending, the original license does not expire while that's being processed. And so these regulations then confirm that, and they provide a way to take advantage of that statutory provision and protect officers if their application is in the process of being reviewed and decided on. Section 704 deals with conditional recertification, concept that I mentioned a moment ago, and it provides that a conditional certification shall be issued or may be issued depending upon the circumstances, particularly where the officer could not be fully recertified due to circumstances beyond the officer's control. And when that's the case, the officer's original certification period, the one granted by the session law, is extended during the new conditional period. So the officer gets double protection, basically. And also the officer is relieved of having to satisfy any conditions that are attached to that recertification before the conclusion of review or a hearing, where the officer might be challenging the decision or the expiration of the time for the officer to do so. And I'll be talking about that review in the hearing in a moment. In section 705, it deals with the process for making determinations regarding the requirement that an officer must possess good moral character and fitness for employment in law enforcement. That's the phrase used in the statute. And it provides that agencies can take into account a range of information and characteristics, things on duty and off duty that an officer has done, commendations as well as negative allegations. And that's something that results from input received from the law enforcement community. Agencies that offer positive assessments might be asked to substantiate them. And agencies that offer negative assessments must substantiate them, and they have to cite specific conduct. And then officers who receive negative assessments can respond to that. And the commission is required to take all of this into account, to look at everything. Now, this regulation also provides that both agencies and the commission generally should not take into account certain alleged conduct in particular circumstances, where an authority has made a relevant decision related to that conduct in the officer's favor, where there's a relevant investigation or adjudication regarding that conduct that's still pending, where the officer has already complied or is complying with a relevant decision related to that conduct and has not engaged in similar conduct since, where the alleged conduct didn't result in any action of a disciplinary nature taken, and there's no clear reason why. So it would raise questions about whether what really happened there. So it would cast doubt on it, so it's not something to be relied on. Or where the allegation is not specifically and credibly supported. Now, there are some exceptions to that rule where there are allegations that an officer engaged in multiple instances of similar or related misconduct. Then that type of alleged misconduct can be taken into account, or where the commission provides protocols that allow for it to be taken into account. So in other words, it's the commission retaining some flexibility to deal with unexpected situations. I just want to point out a revision that was made since the last meeting to that section 7.05. And I mentioned it a moment ago, but I want to make sure to highlight it. This provision that provides for essentially certain matters to generally be off the table in a character and fitness analysis, it's been amended since the last meeting to provide that neither the employing agency nor the Division of Certification within the commission should take that into account. So that's a change that's been made. Section 706 is then the section that goes on to discuss point by point the different requirements in the statute and to explain how a failure or an inability to satisfy each of those requirements will be treated by the commission. And as I've discussed before, you can basically think of it in terms of 4 categories. One is where there was an inability to satisfy the requirement that's attributable not to the officer, but to the employer or to the MPTC or to the commission. Then there'll be a conditional recertification with a modest amount of additional time to satisfy the requirement. And if it's because of a failure to satisfy the physical and psychological evaluation requirement because there was none in place, this would provide for the implementation of a commission policy. And in fact, the commission has already, back in March, adopted something related to that matter. Where there's an inability to satisfy a requirement because the officer was given less time than others because of where the officer falls in the alphabet, then the officer is basically equalized with the other members of the alphabet, being given a conditional recertification with an allowance until 2024 to satisfy the requirement. Where there's been an inability to satisfy a requirement that existed previously, however, then there's a conditional recertification with only a modest amount of additional time. And when there's an inability to satisfy certain requirements that an officer can't cure or should not be allowed to cure, such as a felony conviction, then certification will not be renewed and it's allowed to expire. Now here too, I just want to point out some revisions that were made since the last meeting. There are a couple things that were clarified because, as you may have seen in the regulations, the version last time essentially provided in one place that an officer shall receive a conditional certification. Other places, officers may receive a conditional certification. Another place, an officer shall not be recertified at all. And there could be situations where an officer falls into multiple of those categories. So then would we be giving inconsistent directives to the certification division, or where they'd have to decide which one supersedes the other? So there were some changes made that would clarify that, and they would provide that the provisions of section 704 that I mentioned earlier that deal with conditional certification and exceptional circumstances, those supersede the provisions of 706 that would ordinarily call for a particular outcome to be taken. Then provisions of section 706 that would require a denial of recertification supersede the provisions that would call for conditional recertification. So in other words, if the inability to satisfy one requirement would ordinarily lead to a conditional recertification, but there's something else that prevents recertification altogether, then the answer is that there would be no recertification. And I'll just show those insertions that would put that into effect were included in the background check requirement, the oral interview requirement, and the character and fitness requirement. Then there's another change that was made, and it clarifies that any way of satisfying the oral interview must be in accordance with commission policy. Really, that phrase, in accordance with commission policy, was already in there. It was just in a different place. So by moving it to the beginning, we made clear that whatever is being done as part of this oral interview process is consistent with commission policy. Sections 7.07 to 709 follow, and they provide for the commission to evaluate the application and provide notification to officers. They provide that a new certification is retroactive to what we're calling the reference date. So in other words, the original expiration date. So again, there's some added protection there. Nobody should be able to come along and say, well, during that 1 month period or that 2 month period, this officer was out there making arrests and exercising law enforcement duties without the legal authority to do so. This provides some added protection that that such a claim could not be made. That's not what the commission intends. It also provides within this part of the regulations that the commission can limit the recertification if necessary. The next sections, section 710 and 711, they include provisions that I made reference to earlier, that an officer can seek review by the executive director. We understand that officers are concerned about the possibility that an agency official will make a negative report to the commission that the officer would want to challenge, not only in the way that we've already provided by allowing the officer to provide a response to a negative character and fitness assessment, but by allowing a further opportunity to challenge or seek further review of the commission's decision by taking it up with the executive director. And then if the officer is still dissatisfied, they can seek further review through a hearing. And that hearing would be conducted, as I alluded to earlier, through the same regulatory process that we developed, that the commission already approved in a prior meeting. Then if a recertification is somehow vacated, that does not nullify the period in which the officer was certified until that vacation decision comes out. So in other words, again, this heads off a claim that in fact an officer was unwittingly acting without authority. The idea is the officer had authority until the commission says otherwise. These provisions also provide that the commission can restrict an officer's ability to reapply if the officer has been denied a recertification. But it does also provide that prior to the conclusion of a review or a hearing, or the expiration of the time for seeking a review or a hearing, the officer's application is not finally determined. And so in other words, the original certification period continues. So in other words, it refers back to that provision that I mentioned a moment ago that's grounded in statute. I do want to point out a new section that was added since the last meeting at the very end, and this would make the regulations expire on June 30th, 2025. So in other words, at the point when the last third of the alphabet comes up for recertification and taking into account any time allowed for their applications to be processed, building in a good amount of time after that, it would provide at that point, these regulations would expire because they're mainly written with these first 3/3 of the alphabet in mind. Now, of course, the commission could readopt the regulations at that point, but if it doesn't, they would expire. Now, there's another provision that I would suggest that the commission adopts, and it's not included in the draft, but it would recite a finding by the commission that the immediate adoption of this provision these regulations are necessary for the public health, safety, and general welfare. And it would say that in addition to that, observance of the requirements of notice and affording interested persons an additional opportunity to present their views would be, at this time, would be contrary to the public interest. And it would explain that this finding is made specifically because the certification of officers with names between A and H are coming up to expire on July 1st. That's the reason why this needs to be adopted on an emergency basis. And why do I suggest including that provision? Because the statute that deals with emergency regulations says that if an agency feels it's necessary to adopt a regulation on an emergency basis, it needs to make a finding of that type. So it needs to state those things that I stated and provide a brief statement for why it makes that finding. Then what does it mean for a regulation to be adopted on an emergency basis? Well, what it means is that it goes into effect right away, but it doesn't stay in effect for more than 3 months unless during that time the agency takes the steps that ordinarily, without an emergency, would be done before the adoption of the regulation. So giving notice at least 21 days in advance as provided by statute. So that includes publication in newspaper, providing notice to those who have requested it and so forth. And also notice to the Secretary of the Commonwealth accompanied by a small business impact statement. Also affording interested persons an opportunity to present their views in the way that's spelled out in the statute. That's something else that would need to be done in that 3-month period in order for the regulations to stay in effect, and filing a notice with the Secretary of the Commonwealth showing that these things have been done. And if those things aren't done, then the regulation expires. Now, I will note that the comment period, or the period provided for the public to provide comments, is 21 days. And when an agency adopts regulations after providing an opportunity for public comment, they need to provide 21 days. And if they're doing it on an emergency basis, they need to provide 21 days after the regulation is adopted within that 3-month period. And part of the reason why I went through the background at the beginning is to show that in fact, much of what is in these current regulations has actually been out there for 21 days or more in some cases. And there have been opportunities for public comment. Now, don't get me wrong, the steps that were taken to publicize it were not exactly what is provided in this provision of the statute. So we'd still need to take those steps. But this is not a situation where these regulations have not been out there in some fashion for a significant period of time. They actually have been out there for at least the amount of time that ordinarily they would be out there if we were doing a formal notice and comment process. So then that leaves the following timeline. And I won't go through every step, but basically if the emergency regulations are approved at this meeting, there would be a series of steps that would be taken. And then in mid-July, the public comment period would close. And then shortly thereafter, further steps would be taken and the regulations would become permanent, assuming all the I's are dotted and T's are crossed in early September. However, if those steps are not taken, then the regulation would expire roughly around the same time. So I can answer questions if people have them, and if the chair would like me to.
Yes, I would entertain any question from any of my fellow commissioners of that very detailed, careful discussion and outline presented by our general counsel. Commissioner Kazarosian, and you're on mute.
Thank you. And thank you, Attorney Ravitz. That was excellent and very helpful to me. My question is, do we need to have a motion to approve these as an emergency regulation? Is that what you had? I wasn't sure on the last part whether we need to move for the reasons that you stated that were articulated in 30A. Do we have to move that we adopt these on an emergency basis?
The commission would need to approve that. And then what 30A provides is that finding along the lines of what I mentioned should be included within the regulation that's then submitted to the Secretary of State. Okay. So I was suggesting that maybe the easiest way to do that is just to add a new section, call it 713, and recite that finding. But yes, with the commission making it clear that that's its intent is to adopt these as emergency regulations.
Okay, understood. Thank you.
Other questions or comments from the commissioners? Yes, Commissioner Ellison, please.
Yeah, Attorney Ravitz, thank you for that as well. Just a quick question on the public response. The 21 days, does that start from the time that if this was approved, would the clock start then for the public response?
The clock, the 3-month period that we have to get those things done to make the regulations permanent, that would start today if the commission approves this. But the 21-day period would start from whenever the commission take steps to formally post notice and give the public an opportunity for comment.
Thank you.
Other questions, please? Yes, Commissioner Bluestone, please.
Yes, thank you again, Attorney Ravitz. That was really also very helpful to me as well. I'm wondering, would it be possible to bring up the section 705, where we have the language for good character. I'd just like to make a comment on that.
I might have a little trouble with the technology.
Can we ask Maurice to bring up, Maurice, if you can bring up the packet, are you able to? With the actual, not the PowerPoint, but the actual regulations.
And 705, Commissioner Bluestone, is rather lengthy. Do you have a
Yeah,
particular? subparagraph?
it's 705 2A little I.
On page 4 of, is that correct?
Correct. Yep.
Thank you.
And I guess while we're doing that, my comment is basically, at our last meeting, we heard some feedback, which I thought was compelling about the language that we've chosen to kind of start to operationalize this idea of good character, which I think is a difficult concept. And it was suggested that perhaps this language could be construed as overly abstract. I think it was characterized as a Boy Scout standard. And Attorney Ravitz explained at the last meeting that the language has come from an accepted standard that has been endorsed by the courts for bar admission as a standard of good character for bar admission. And I was not aware of where that language had come from, and I raised some questions about that because I'm wondering if the standard for bar admission is really the standard that we should be applying when we think about law enforcement. And I think both Commissioners West and Ellison made compelling points. I think Commissioner West suggested that the language or the standard that we adopt for law enforcement, given the level of authority and responsibility that goes along with that role, should in fact be higher. And Commissioner Ellison, I think, pointed out that the standard really for law enforcement applies to both their professional behavior on the job and even in certain instances off the job. And I would just ask the commission to consider maybe an alternative definition, because there is within the law enforcement community very well accepted standards of codes of conduct and ethics that have been endorsed by the IACP since 1957 that I do think reflect a higher standard of professionalism. And I would just like us to consider at least whether we go in a slightly different direction from the language that we have here. And Attorney Ravitz has spent some time on this and come up with an alternative definition, which as you read this,
the original
would focus our attention a little bit away from the idea of trying to define good character and really giving some more directive around the areas that an employing agency might wish to consider when they're making this attestation about an officer's good character and fitness. And I think that there are really perhaps 3 elements that seem well accepted in this regard. One would be that that the officer is also adhering to legal standards in their personal lives, that they are adhering to the code of conduct and ethics that are accepted standards within the profession, and that they are acting in a way that maintains the public trust. So the language that Attorney Ravitz came up with is slightly different, and it would read like this: in assessing good character and fitness for employment, an employing agency may take into account whether an officer adheres to state and federal laws acts consistently with recognized standards of ethics and conduct for the law enforcement profession, and is worthy of the public trust and of the authority given to law enforcement officers. And I would just ask us to consider that as an alternative. And if anybody has additional comment, would be interested.
May I inquire, Commissioner Bluestone, you made reference to an IACP standard initially. Is that the language that you've just utilized, or is this from some other source?
This language would merely be directing the employing agency to look at those standards, which are well established for law enforcement officers, and they are codified by the IACP, both in their codes of conduct and their code of ethics, which are well accepted, as I understand it, within the law enforcement community. And it's just my feeling that when we're asking for this assessment to be made, that we are relating it back to the standards that are established already within the law enforcement profession.
Questions or comments from the commissioners on the request of Commissioner Bluestone to substitute the language that is currently on the screen for what is currently under 705(2)(a)(1), as I understand it. Any other questions or comments? And then I guess what I would do is entertain well, let me see, first of all, I wonder, can you just eliminate the screen sharing so I can see the entire commission, please? All right. Yes, Commissioner Wynn. Commissioner Wynn, please.
Thank you, Chair Hinkle. I would support that change. Thank you, Commissioner Bluestone, for making that suggestion.
Commissioner West.
I want to make sure that I understand exactly where the language is coming from. Is this based off of the IACP recommended language?
No. My view is that every profession has its own set of ethical standards and codes of conduct, and that the law enforcement profession is no exception. And in fact, their standards are higher than the ones that other professions, like for the bar or for psychology, let's say, would adopt, given the recognized authority and responsibility of their role. And so officers already adhere to those codes of conduct and ethical standards as adopted by the IACP. And I would simply suggest that as we advise employing agencies to make these attestations, that we're just referring them back to their own ethical standards and codes of conduct, to consider that as part of the overall assessment. Which I think is something that we do in every profession. So I don't think it's asking anything out of the ordinary.
Yes, Enrique, please.
If it pleases the chair and the commissioners, I have available the code of ethics of IACP if you want to reference it or see it. It's a one-pager.
But just to be clear, are we referencing IACP, or are we referencing each department's code of ethics and code of conduct?
I would have to defer to one of the law enforcement officers on the commission, because I do think that there are variations, but I think that there is universal acceptance of the IACP code and code of ethics and conduct.
Okay, so the answer to that would be helpful. I'm not sure if Chief Wynn or.
As I understood the language drafted by Attorney Ravitz, it simply would refer me as a attesting officer to the code of conduct and code of ethics accepted in the profession. So my department, for example, includes the IACP code of ethics in our rules and regulations. Other agencies may use another fundamental document, but it would be a professional standard from one of our certifying agencies.
Yes, Commissioner Keserosian. Thank you, Commissioner Wynn, for that. But I think there's a question from Commissioner Keserosian.
Well, yeah, maybe a suggestion and sort of following up on what both Commissioners West and Wynn were talking about. Would it make sense then to be consistent with agencies across the board to have some reference to the IACP ethics or code of conduct? Because if that's what this standard is, I think all agencies should be looking to the same standard and not having their own standard. I think that would be a little more consistent than letting each agency use their own. And the IACP is obviously very well respected in the law enforcement community, and their policies and standards are, the gold. It's the gold standard. So I'm suggesting maybe we have, if we're going to do this, have some kind of a reference to the IACP.
Commissioner Ellison.
Yeah, just Chief Wynn as well, just a follow-up to that. But that behavior and that compliance is on and off duty. So I think that's a common factor regardless to whether it's tweaked at some other department in minor language, but it's applicable to on and off duty. And I think that's the key for me, is that this to be in compliance with whether you're on duty or off duty in the language.
So may I just inquire then, would you endorse the suggested change of Commissioner Bluestone?
I would, but as long as it was also including the on and off, because I know that I believe one of the questions in the last meeting was that it only apply while the officers were working, and I don't think that's a standard that would work, because no department has a standard that doesn't regulate your behavior off duty, and the commission should not adopt one as well.
Yes, and Commissioner Luma, please.
Yes, and I'm just responding to the suggestion that we adopt a specific standard. I'm wondering if departments already have code of ethics and standards in place already, would we just require that they reference what those code of ethics are or standards are, or provide documentation or just attestation that yes, we do have this in place, rather than have multiple departments adopt a specific standard when they already have things in place? It's just a question that I would pose to some of the law enforcement officials. I just don't know what the variation in those standards look like, and how difficult would it be for departments to adopt a new standard or code of ethics if they have one in place.
Commissioner Calderon, do you want to respond to that?
I'll take this one. Yes, Chair. Thank you. Commissioner Luma, I agree with you. I agree with Chief Wynn. I agree with Bluestone and Commissioner Ellison on all the fronts that they're saying. I think that each individual department has their own code of ethics and their own rules that they go by. And I can't pretend to know what happens around the Commonwealth, but if we are going to adopt a set of guidelines that relies on ethics by the departments, I think the chief is spot on that it would be the individual department's code of ethics. Other than that, we're going to try to, in the next couple of weeks, figure out what 351 communities I have around the Commonwealth, and then try to formulate one document to go by. So I hope I'm answering what you're saying, but I believe you and Chief Wynn are spot on with where you're going.
Thank you, Commissioner Calderon. Commissioner West, I think I see your hand in the air, and then Commissioner Bluestone.
Thank you. And and I think that this language makes sense. And I agree that the IACP really is a very well-respected organization. And so I think the source of it is, I'm very confident in the source. But the issue I raise was just raised by Commissioner Luma. I don't know how we include this language when, number one, we don't know if departments out there even have a code of ethics, and if they do have a code of ethics, they are likely going to be somewhat different. So my suggestion is that we tie this language to, at a minimum, the IACP Code of Ethics in the absence of the department's own code, or where a code is not as thorough as IACP. I think this is a really good idea, and I have a lot of confidence in the IACP.
Commissioner Kazarosian, or no, I'm sorry, Commissioner Bluestone, please. I think your hand was in the air first, and then Commissioner Kazarosian.
I just wanted to respond to Commissioner Ellison's point, which I think is an important one, and which is reflected in the IACP standard, which says, I will keep my private life unsullied as an example to all and behave in a manner that does not bring discredit to me or my agency. So it is reflected in that standard, just to be clear. And I think secondly, I would just point out that the language, if we adopt it, says that the employing agency may take into account whether an officer adheres to the recognized standards of ethics and conduct. And so we're using that as a way to anchor the evaluation and the assessment. It's one aspect of it. And I think in that guise, we could suggest that they refer to specifically to the IACP standard.
Thank you. Commissioner Kazarosian.
Yes, I was going to suggest the same thing as well, because I don't want anything to be misunderstood that we're suggesting that all these departments now have to change their code of conduct or modify them or conform them. But if it at least, this is just what some of the things that can be considered when determining good moral conduct, and to point to the same consistent place, which would be the IACP, even if we added it at the very end of that last sentence, Commissioner Bluestone, that you had just read, because it's just one of the considerations. It's not the be all end all, but at least it's a consistent consideration to an organization that's highly respected across the board in law enforcement.
Other questions and comments on this precise issue? Yes, again, Commissioner Calderon, please.
Is it possible to ask Randy or someone to find the IACP Code of Ethics and put it up on the board? I'm not sure that everybody that's watching in the gallery even knows what the IACP's code or standards are. If we have so many police departments that are working under their own guidelines, I'd be hard pressed to vote in anything without consulting with the other groups of people that are sitting in the audience that maybe haven't had a chance to even look at this.
I'm able to put it to share on the screen, Madam Chair, if you think that's something you want me to do.
And I'm sorry, I missed the first few words that you said. Can you respond to Commissioner Calderon by putting that on the screen?
Yes.
You're able to do that. Oh, thank you very much.
I'm pretty sure I need a moment to just open it up so that when I share my screen, so give me just 1 minute.
Thank you.
I'll try it now. Can everybody see this?
Yes. Madam Chair, I see that Commissioner West's hand is risen. So if you wanted to, while Enrique scrolling.
Yes. I'm sorry, Commissioner West, please.
Thank you, Your Honor. As I said, I think the IACP is the gold standard, and I would be surprised if police officers and departments didn't know what it was. But bearing in mind Commissioners Calderon's comments, I think the language could be that I think Commissioner Bluestone said may take into account whether the officer adheres to, and we could have adheres to the department's code of ethics and conduct and or the IACP code of ethics and conduct, so that the officer is not going to be held to the IACP code of conduct if it's particularly different from its own department.
Okay. Is there any other reason to keep this definition of screen that is put on? Does anybody need further time to look at that? I think we can stop that screen sharing, please. Thank you very much, Enrique, for pulling that up quickly. And I think we now have a suggestion from Commissioner West, perhaps as a clarification. I'm still looking to have something specific that we can work with. Do you want to just repeat that, please, Commissioner West? And let's see what the others think about that.
It would be helpful if Mr. Ravitz could put up the language again, and then we can make an insertion.
Yes. And Commissioner West, I'm trying to capture what you just said a moment ago. And
Mhm.
And I think you just would want an as before set forth in that middle line.
Yes, I think this gives then the officer the option. It need not be IACP if they're acting consistently with their own department's recognized standards of ethics and conduct.
Randy, thank you for so quickly putting that together. May I ask once more about questions and comment? Yes, Commissioner Kazarosian, please.
Because there's the ethics and conduct in the beginning, I'd also, if Randy could put that back up on the screen, because there's one other place I'd like to see ethics and conduct when it refers to the IACP, to make it consistent with what Commissioner West had said. So as set forth in the Law Enforcement Code of Ethics and Conduct adopted by the International Association of Chiefs of Police.
But is that the title?
There's a code of ethics, and then there's the standards of conduct for the international chief. So they have both, just as it's referred to in each agency. So it says recognized standards of ethics and conduct adopted by the employing agency, or as set forth in the Law Enforcement Code of Ethics or standards of conduct adopted by the IACP. I would say, or standards of conduct. I would add that in there to be consistent.
is that capitalized? Is that
Capitalized
formal?
standards of conduct, yeah. Thank you.
Other questions or comments from the commissioners on replacing Commissioner Bluestone's suggestion, endorsed by several others, of replacing 705 2A(1) current language with this language?
Mr. Nguyen has his hands up. Commissioner Nguyen has his hands raised. That's smart.
Sorry. Yes, Commissioner Nguyen, please.
I just want to double check something, because I don't disagree with that suggestion and that addition, but the IACP Law Enforcement Code of Ethics was specifically voted on in 1957. I don't think that's the case for the standards of conduct. That's a separate and more recent document. I just had it up but I closed that screen and I can't find the date.
I think that's,
You-
I think
You're
that's
right.
right.
I think it's June 2020 for the code, for the standards of conduct.
Or how about the most recently
Yeah,
adopted?
the most recent, sure.
Would that be acceptable, Commissioner Wynn? All right. So does somebody want to make a formal motion just to replace this language with the original language with this language, and then if there's any further discussion of the regulations among the commissioners, we'll take that up, and then we will have any public comment before we take any vote on the regulations as a whole.
I think,
there a form-
you need a motion first.
That's what that's what I'm saying.
But I think you need a motion on the entire document for clarity. So the motion would be the document, I think this is the right version, Randy, that Attorney Ravitz circulated to the commission earlier today, and replacing 705-2A1. I assume that's the both sentences in that paragraph with this language. That would be a motion if someone wanted to make it, and if that motion was approved, then you would get, I think, where you wanted to get to.
All right, here are the two sentences in that paragraph, that original paragraph.
Right, so I was
So-
unclear if you wanted to get rid of the first one with the, replace the first one with the new language, or replace both with the new language.
Commissioner Gazarozian.
I thought my understanding was we were talking about just the good moral character, so it would be the first sentence.
That was my understanding.
That's what I just wanted to be clear on. I think that's, I mean, Commissioner Bluestone started us off, and I think that, I don't want to speak for her.
That would be my understanding as well. That was, I think, the intention to ask for reconsideration of that first sentence.
Okay,
Once again, Attorney Povich, what you are recommending to us is that we take up at this point a motion.
yeah, you can have further discussion if you want, but just to make clear what's on the table is a motion to approve the emergency regulations. I think Attorney Ravitz circulated the whole draft at some point, right? Or to the commission with a modification of replacing the first sentence of section 705-2A1I with this in language that is now on the screen. So if someone would make that motion and it would be seconded, there could be further discussion on the motion, but at least we'd have in one place what we're considering, what the commission is considering adopting as an emergency regulation.
All right, thank you, Attorney Povich. I would entertain such a motion.
So moved, but I can't repeat it exactly.
Is there a second to the motion that we would be approving what was circulated to each member of the commission by our general counsel early this morning with this suggested change? That's as I understand it.
I would second that motion.
And I think, I'm sorry, is there any further question or comment among the commissioners? Yes, Commissioner Calderon.
I'm sorry, Madam Chair. I just want to make sure I understand this correct. We're just modifying the document that was sent to us this morning, adding in what we just discussed, correct?
We are adopting, we would move to adopt that document. Isn't that what we're moving to?
Yes, yes, the document that was circulated this morning with one sentence switched out, the first sentence of.
Replace.
That's what I was trying to ascertain. So we're voting on the entire regulation document itself, not just the change.
The
Well,
emergency.
you're right, because the regulation, we can do it some other way, but we need to start with one document and then see if there's other, if you want to make other, if you want to discuss other changes to the document, or if you want to discuss voting now or not voting now is the time to do that with this motion before you.
I want to make sure that I'm clear on, and all the commissioners are clear, because I don't know if I'm the only one. Are we only voting on changing what the motion stated by adding into this section, or are we voting on the whole regulation itself at once?
The motion that I
Right.
suggested was the whole regulation at once, but you could make it subject to further amendment if you wished, or a discussion about whether to vote it, but I just wanted to have the whole, there was nothing to amend, but there was no place to put that sentence till we put the whole thing before the commission.
No, that's fine. If we're voting on the regulation, I just wanted to be clear. That's all. Thank you.
All right, so Commissioner Casarosan, do you want to just clarify what your motion is in response to Commissioner Calderon?
Yes, I'm moving to adopt the regulation with the change of this section that's on the screen, talking about substituting the first sentence of the original document with this document on the screen here, the language relative to good character and fitness for employment that refers to the IACP codes of ethic and standard of conduct.
Thank you. And Commissioner Bluestone, is that what you seconded?
Yes, it is.
Is there any further question or comment before we take the vote? I think with that, Commissioner Bluestone,
I vote yes.
Commissioner Calderon,
I vote no. There are too many outstanding issues in the regulation itself. I'm a no.
Commissioner Sherry,
Yes.
Commissioner Ellison,
I'm going to abstain at this time.
Casarosan, you have moved for it, so you approve it.
Yes.
Commissioner Luma,
Approved.
Commissioner West,
Approved.
Commissioner Wynn,
Yes.
and I vote
Mhm.
also, I vote also in favor. So the proposed regulations with that modification have been adopted on an emergency basis with 7 of the commissioners voting in favor, 1 abstaining, and 1 voting in opposition. Other, is there, and I think at this point, fellow commissioners, I would take up public comment, if there is any public comment.
So far, one person has identified, Senator Collins staffer has identified that the senator would like to speak.
Yes, I'm gonna bring him up.
I don't know if he's with.
Yeah, I'm gonna bring him over now into the panelists.
Thank you very much.
Senator Collins, you were with us, yeah.
Senator Collins, welcome.
Thank you very much, Madam Chair and the Commission. A really healthy back and forth, and I appreciate the deliberation that was just made on the section and matter before you, because I think it's so important, as I mentioned last time, and I know the Commission is taking this seriously, about the objective nature of your role and how important that is to the integrity of not just your early regulations, but the decisions that are made throughout. And I know the regulations were just adopted, but for the same reasons, I think you amended section 7.5 subsection 2A I. The part of the proposal, I guess it would be under the assessment and determination by the commission, page 6 in the draft. The Division of Certification may, to the extent reasonably possible, obtain additional information that may prove helpful in determining whether an officer possesses good character and fitness for employment. I'm just curious as to, similarly in the language that was amended, the purpose, and what limitations the commission may see could come out of the combination of information that's part of the review up front, the attestation, report from the agency and response, and sort of what entities, whether it's, government agencies that have this information, because it sounds a little bit like, Elliot Ness and the Untouchables at a certain point. If it's not pinned down as to where information, if it's sort of open-ended on the reviews. Now, if there's misconduct, of course, and that's what's before the commission, that's one thing, but on the review of certifications, that there's, I guess the intent of that is sort of unclear as it's written. And if you're looking at this and you're also looking at the questions that were put forth that are still up for consideration, particularly in and around questions of bias, is being accused enough where that individual has to respond in the questionnaire. So they're not the same, but they're tied as the regulations are now forward and approved. And so I'm just, for the attorney Ravitz, who put forward the draft, just, and that was highlighted as amended, what the examples are, or sort of what the route you think the agency would have to take. Because it's, to me, at least at the certification level, on the same page, you're talking about, sort of standard things. This is, sort of an open-ended one that I was really trying to get some clarity on, because it seems like with all the other adjustments that were made and sort of speaking to standards, that this was a little bit open-ended.
The chair would.
Senator Collins, thank you very much for your comments. As you know, we've adopted these as emergency regulations. I think we will weigh what you have said here, and we will take that into consideration in the period of time between now and the time that the regulations may be formally adopted. I think it is, you've raised several matters that we will take into consideration, and we appreciate those comments.
Thank you.
Maurice, I believe there was someone else who wanted to speak. Madam Chair, is that?
Yeah, I think we have three. I think there are three.
So I'll go in the order that they came in, that's showing up right now. I'll start with Anne Marie G and pull her or him into the room. Give me a second. Okay.
Anne Marie Grant, for the record, sister of Thomas Purdy, murdered by Reno police October 8th, 2015 during a mental health crisis. He was hogtied and asphyxiated, hogtied for over 40 minutes, his crime asking police officers for help. How much promotion was done for this meeting? 0. That was the answer at the beginning of the meeting. Outreach is critical if you really want public input from community members, not just law enforcement, who seem to be well aware of these meetings. Meetings are posted on the website last minute. I'm aware of the 48-hour law, but you could accommodate and be a little more proactive. Seems you don't really want comments from the public based on the minimal efforts you've put forth to make the public aware. What would trigger a non-recertification besides felony charges? Oh, and I don't expect any answers because you couldn't even answer our lawmaker's question. So how many internal affairs investigations are we going to tolerate from one officer? This meeting was not publicized per the statute. Why not? You got one public comment from law enforcement officers. The average citizen's voice doesn't. Sorry, somebody muted me. To this committee, if you really cared, you'd be publicizing it by the statute. The open meeting lawsuit by police unions are probably valid based on the above MO of this commission. Sadly, the unions are only filing it to stop efforts at accountability, i.e. the recertification process. The clock starts today. I want to see extensive efforts to make the community aware. Police literally can kill without consequence. So you need public input on this matter. They investigate themselves in this recertification process truly will be doing the same exact thing. What will audits look like of certifications that are signed off on by those responsible to decide if an officer should be recertified, i.e. another police officer? Very specific detailed language is demanded and dire. Why are we going to leave it up to every single agency's code of conduct? There needs to be one code of conduct regarding good character. Is good character 2, 3, 4 internal affairs investigations? Not to mention the hundreds that are listed on Boston PD that are unknown officers who actually perpetrated the acts allegedly. Example, officer from Boston PD, David Godin, shot and killed Justin Root, mentally ill. Justin Root shot him downtown, sandwiched in between 2 mental health facilities. And then after he shot him downtown, got in his vehicle and drove all the way to Chestnut Hill, and him and several other officers shot gravely wounded, semi-comatose Justin 31 times while he was on the ground. Perhaps had his prior 4 internal affairs investigation disqualified him to be a police officer, Justin would be alive. The questions about psych evaluations do nothing for transparency in the recertification questionnaire. Law enforcement officers should have to mandatorily be psychologically evaluated yearly. Again, they can kill without consequence. All they have to do is say they feared for their lives. The standards may be written as a higher code of conduct, but the unions and collective bargaining agreements ensure, even if they violate that code of conduct, there's no accountability. Again, everything should be spelled out regarding language, in my opinion. No body cams were activated when Justin Root was shot, except by 1 officer at the second shooting scene. That goes against BPD policy, yet no repercussions for any of those officers for violating policy or code of conduct. Just goes to support the idea police cannot be left to police themselves with anything, including this recertification process. And no offense, but the age range of the committee members are not representative of what an entire community looks like. And 2 law enforcement related members is too many. Thank you.
Attorney Povich, did you say that there was another individual who wished to appear in front of us?
There's actually going to be 2. I missed, I believe it's a P Bryant at PYLEROME.com. He had his hand up first. I'm going to bring him into as a panelist now.
Thank you.
I don't know if he dropped off, but it looked like he dropped off somehow. I'm not sure how, but I'll go to the next one that we have, which is the, excuse me, where is it at? A Law Enforcement Dimensions LLC. Oh, there goes Mr. I'll get Mr. P. Bryant back in here. Hold on there. Sorry about that. All right, he's going to be joining the room shortly, or she.
Hello.
Hello.
So, hi, I'm Patrick Bryant. I'm an attorney for the Boston Police Superior Officers Federation and also for Massachusetts Coalition of Police. And along with the Boston Police Detective Society, there was a letter that was sent earlier today about these regulations. And I just want to highlight some of which is we understand that I think the committee should redouble its efforts towards transparency. So at the beginning of the presentation by the attorney, the fact that issues may have been discussed at certain points in meetings is not sufficient to place people on notice and to fulfill the requirements under the law that when you're going to have regulations that set forth standards, there should be sufficient notice and opportunity to comment on them. And it's not enough the fact that a concept was vaguely discussed at a meeting to do that. Secondly, the discussion today, particularly of the regulations before there has been public comment and going for an emergency, highlights an absurdity that's going on, because right now the commission is requiring agencies across the Commonwealth to do an attestation that is not permitted under the law, but nonetheless is delegating this heavy work to these agencies to do. And the commission hasn't yet issued what the regulations are regarding recertification. It is, to put it mildly, putting the cart before the horse. How can you have regulations that aren't yet finished, particularly that involve very core areas to this case, and to how officers are to be recertified, and at the same time you're requiring good moral character as of this very moment to be judged and attested to by various people, and you haven't decided what that means yet. As part of that, what I still think is a problem is how the commission is seeking to define good moral character and fitness, even under the change that was put forward today, remains absolutely vague as to what is to be applied. So good moral character and fitness for employment is supposed to be a standard statewide for all law enforcement officers. You have just put forward, and through this delegation process, said good moral character and fitness for employment more or less is to be defined within every municipality as to their own standards. And the addition of, and what I would also say a problem is, the addition of the IACP is very problematic. It is Pollyannish, to put it simply. It is, there is nothing wrong with having something aspirational to say, this is how we expect and want our police officers to behave. But are you really going to say someone lacks moral character and fitness for employment if they do not, as set forth under the standards of the IACP, dedicate themselves before God to their chosen profession? Is that the standard that the Post Commission is now saying, that someone who is insufficiently religious, insufficiently servile in that setting now must be decertified because they lack good moral character? The other problem is the regulations say you may take into those factors to define good moral character. Well, if those factors define good moral character and fitness, it shouldn't be an option. And so the regulations don't provide for any consistency in how good moral character is to be defined. Plus, you're relying on, again, without further definition of what good moral character or fitness means, you now have the likelihood that an agency is going to define those terms differently, then the Post Commission is going to define those terms, then the Division of Certification is going to define those terms, then the Executive Director is going to define those terms, or to the Division of Standards is going to define those terms. And that is going to create, I think, an enormous problem. So then what also should be clear is when these this process occurs for moral character, is it should be clear that we're dealing clearly with conduct that has occurred since officers have been certified and since this legislation went into effect. So it cannot be that the legislator saw fit to automatically and unconditionally certify 10,000 officers, and suddenly conduct that occurred, discipline or otherwise, prior to these standards being into place, and them still being certified after the fact by the legislature, suddenly can be used as a basis in which to evaluate someone's good moral character or fitness. There also should be the
Attorney Brian, I'm going to, I did ask the comments be restricted in terms of length. And so I am going to, at this point, ask, please, for our next speaker. I'm also mindful of the fact that your firm is representing one of the parties in the ongoing litigation in Suffolk Superior Court, and we therefore have to be cognizant of the fact that there is ongoing litigation addressing some of the issues that you have taken up. Thank you.
I've only been addressing respectfully the issues of the recertification regulations that have been put up for public comment.
Thank you.
So,
Thank you. We will take into consideration the comments that you have made.
There's one more.
Was there another individual who was to address us?
Yep. Law enforcement dimensions. All right, I'm going to bring this group in now as a panelist.
Hello, commissioners. I appreciate your listening to me. I appeared before you in an earlier meeting. My name is John Sophisheft, and I'm an attorney. And I represent the Massachusetts Police Association. And I just have a very short thing to recommend, and it actually follows nicely the last speaker. I know that you're currently involved in litigation, and really the basis of the litigation is open meeting issues. It's also the recertification process, and in particular, the law enforcement questionnaire. You know, my client, the 18,000 police officers, past and present, that I represent, we chose to file recommendations to the commission, and we understand that other groups in law enforcement thought that the litigation approach might be the best way to air their concerns and preserve their concerns. My hope is that there'll be some effort to mediate, to talk privately. I think my sense is that the commission is, this is a work in progress, and I know that you want to do the right thing. You are open to some changes in the questionnaire, and you've certainly been open to redefining the definition of moral character and fitness in a way that's consistent and compatible with the profession. So I just wanted to take the opportunity, and if there's any way that the MPA or I can be a participant or helpful in some kind of mediation or settlement discussion, we'd certainly love to participate in that. And of course, always with litigation, mediation is confidential. And if the parties feel they need to pursue the situation in court, they can certainly end up doing that. But I think where we're at a point right now where no officer has been truly affected yet by this process, no member of the public yet has been affected. Now is the time for the parties in the litigation to meet and really see if we can come up with the process that we know that people are interested in, especially the public. So I just wanted to encourage the commission to, I'm sure you probably already are, but I wanted to add my voice to people who are encouraging you and the other parties in the litigation to try and just let's come up with something good while we can. Thank you.
Thank you, Attorney Schiff. And is there anybody else who wish to appear in front of us? Maurice or Lon?
There are several hands raised in the.
It's the same
that,
gentleman.
Maurice?
Yeah,
Dan
dude.
Purdy and Peter Peroni.
Yep. Yeah, there's also the Patrick Bryant gentleman that was just on here. So I'll go in reverse. Going to bring in Peter Ferrarion. Sorry if I said your name wrong. As a panelist.
Good afternoon and hello to the commission. My name is Peter Peroni. I will say at the onset, I represent the New England Police Benevolent Association, which is involved in some of the litigation that you've mentioned, Judge Hinkle. And I raised my hand because I wanted to echo Attorney Schiff's last remarks and Attorney Bryant's also before that. I think they were cogent, but we are amenable to sitting down and talking about this at this crucial point. And we understand that the commission has a very difficult job and is attempting to go through this process very carefully. And we appreciate that. And we appreciate the fact that we're discussing every single word in the regulation involving good moral character. And these are steps we think in the right direction. But I wanted to make clear that we are here. We are amenable to continue talking about these things. And we hope we can find a resolution that's cooperatively reached and serves the constituency of the Commonwealth and the law enforcement officers that we're all here for. So thank you.
Attorney Peroni, if I might just respond that we, as you are aware, we are represented by an Assistant Attorney General, David Marks, in the litigation in which you are representing the party. And really the communication has to go from David Marks, to you on behalf of your client. And I know you're mindful of that.
I am, Judge, and I thought there was an opportunity to support my colleague and what he had said just before me. And I have, I think, good communication with Attorney Marks, and I'll take that suggestion imminently.
Thank you.
All right. There are still two hands raised. I'm going to get, is it Dan Purdy into the here as a panelist? So. You're in the room, so you're just muted and no video.
Sorry about that. Daniel Purdy for the record. I do not believe that the police should be investigating the police. I mean, the head of the police union, we just had a pedophile in the police union. For how long? People had to know about it. And every policy in place did absolutely nothing. There needs to be one code of conduct for everyone. I mean, it's just so simple. One code of conduct for every police officer in Massachusetts. And then there's just no confusion on anything. Body cameras are an absolute must. If they are not turned on, absolute violation, needs to be suspended. And this being suspended, paid administrative leave, especially after a shooting, is just crazy to me. That definitely needs to be reconsidered, but collective bargaining. I really hope that you guys would take the time and take the perspective of the public. I mean, I don't know how much money people make, but I understand when you get up into those six-figure areas, you do become detached from your community. And moral character, I don't know what's going on with that, but I find that pretty easy. Honesty, loyalty, dedication to community, respect to community and others. That sounds pretty simple. Have yourself a great day now. Thank you very much for your time.
Thank you.
There's one more, Mr. Bryant. He was
The
on.
same Mr. Bryant that we have heard from?
Yes, this is Attorney Bryant who spoke before.
I'm going to promote into a panelist, Madam Chair. Is that okay?
Yes.
All right, he's joining the room shortly. He's in the room. Mr. Bryant, you're in the room. You're muted and no video.
Thank you very much. The other things I wanted to get to that we've expressed it multiple times in communications, written communications to the agency, not related to this litigation or the ongoing litigation. Also, is there's a concern about basic due process. So if someone is being tasked as an executive of an employing agency, it is going to attest to whether someone has good moral character or not. There should be very clear that the agency is not using that as an excuse to get around basic procedures that are supposed to be followed in terms of investigations and discipline and things like that. So setting aside the idea of it seems self-evidently absurd that someone is being asked as to whether someone they have employed and tolerated in their department has good moral character and judgment. And if someone is going to claim someone does not have good moral character and judgment, it necessarily calls into question the executive who is employing them on that fact. But if they're going to give something that is a negative assessment, the officer should have an opportunity to respond prior to that adverse attestation occurring. That also, that kind of due process, I think, could be incorporated into other components that have been looked at and was discussed in the presentation earlier. So under 7.05C, it says the Division of Certification can obtain additional information that may prove helpful in determining whether an officer possesses good character and fitness for employment. What that is and what relevance that could be should be more clearly stated. Plus, the officer who has information is being obtained on them should be provided a disclosure of what those materials are and be able to provide a response. It was noted earlier that if someone receives an adverse recommendation by their employing agency, they can respond to the commission. But again, that doesn't promote kind of, I think, fair due process, because at that point, someone has already been flagged for heightened scrutiny, even though the employer, prior to coming to that determination, should have itself, in addition to the commission, provided some kind of due process.
Attorney Brian, I'm going to interrupt you now because we gave you a prior opportunity to speak. I told you that you had exceeded your 5 minutes. I will give you an opportunity to say one more sentence and then conclude for the day.
Well, you had the meeting open until 5 o'clock for public comment. There was no one else waiting. I thought I would just take the opportunity, but if the commission has decided it, and it has not otherwise provided an opportunity for public comment on these regulations in a meeting, then I guess that's it.
Thank you. Attorney Povich, were there any other questions and answers in written form that we need to address?
Attorney Povich, you're muted, sir.
Yes, I'm looking at the list.
Madam Chair, you muted yourself again. Yeah.
Yeah, I think these have all been handled.
Yeah, there's a couple of questions that are public records requests. So I've asked the person to send us a communication to that effect, and we can answer them after this, in due time.
Thank you. Anything else? If not, let me move on to, sorry, is there something
Madam
else?
Chair,
Yes.
there is a question from Chief Bradley of the Mass Chiefs of Police Association that I'd like to address if it pleases the chair.
Yes, go ahead. What is the question?
Yeah, it says, when can the Mass Chiefs of Police Association expect a reply to their letter to the commission? And this is a letter that we received a few weeks ago, and a lot of what's in their letter, even though we haven't responded to their letter per se, is already in the frequently asked questions responses. So I just wanted to note that, and we can continue to have a conversation about those questions, but they've been answered and posted to our website in different ways.
Thank you. Attorney Povich, is there anything else from your perspective in terms of the?
Just give me 1 second if you would, Chair, sorry.
Thank you.
I don't think any of these relate to the subjects that we've discussed today that haven't been responded or discussed otherwise.
Thank you. I don't think that there is any matter not anticipated by me at the time of posting. I want to thank all of the staff for your hard work, your continued hard work, and to thank the commissioners as well for their care and attention to the matters that have come before them. I think with that, I would entertain a motion to adjourn.
So moved.
Is there a second to that motion?
Second,
All in favor?
second,
Commissioner, let me just go through the roll call, please. Commissioner Bluestone,
Yes.
Commissioner Calderon, Commissioner Calderon, Commissioner Sherry,
Yes.
Commissioner Ellison,
yes.
Commissioner Kazarosian,
Yes.
Commissioner Luma had an appointment and had to leave the meeting. She approximately 15 minutes ago. Commissioner West,
Yes.
Commissioner Wynn,
Yes.
and I also approve. Commissioner Calderon, he may also have had to jump off for something. So I think with that, thanks to everyone and to members of the public who have been in attendance at our meeting. Appreciate all of your hard work. The meeting is officially concluded. Thank you.
Thank you.